Stand by pleading true to violation of condition number 4, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in prison and up to a $10,000 fine.
I understand. Yes, ma'am.
Knowing that violation of condition number 4, court will find violation of condition number 4 true. Laura? And then Amy Owen, who do you have?
I'll be right back. I apologize. I was on it.
No problem. I'll call it after this one.
Thank you.
Morning, ma'am.
Good morning. All right, court is calling 2022 CR 2485, State of Texas versus Luis Mora. Could I have parties announced for the record for the state?
Jason Garrett, Your Honor.
Defense?
Jay Moritz, Your Honor.
And are you Luis
Yes, ma'am.
Mora?
Sure.
Are parties ready to proceed on the motion to revoke?
We are, Your Honor.
Yes, Judge.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney?
Yes, ma'am.
And did you understand it?
Yes, ma'am.
Are you the same Luis Joaquin Mora who was placed on deferred adjudication in 2022 CR 2485 for the offense of possession of a controlled substance penalty group 1 gram to 4 grams on April 14th, 2022 for a period of 3 years? Is that you?
Yes, ma'am.
All right, state.
Yes, Your Honor. Violating condition number 4, in their county, Texas, the defendant Luis Joaquin Mora, the defendant failed to report to the supervision officer as directed for the months of January, February, and March 2024, violation condition number 4.
How do you plead to that? True or not true?
That is true, ma'am. Yes, ma'am. Your Honor, we'll waive it.
Any objections?
No objections, Your Honor.
Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in prison and up to a $10,000 fine?
I understand. Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 4? Court will find violation of condition number 4 true. The court doesn't have a trial court certification.
Okay, they're withdrawing the motion. You're gonna go adjudicate? Okay. Oh, I'm sorry, Judge.
No problem.
By the way, congratulations on your YouTube channel.
I'm sorry, what?
Congratulations on your YouTube channel.
Thank you.
Oh, don't play favors with the court,
No,
okay?
I'm not there.
So here's the thing, and this is just for me to make sure that the legal system is transparent. The legal system should be transparent. Everybody should know what's going on
Yes, ma'am.
with the court system.
Yes, ma'am.
And this channel is through the government,
Of course.
through the state of Texas. It's not my channel.
No, I understand.
right.
It. I understand it.
All right.
This is a revocation of your probation, okay? And if the judge revokes you, you do have a limited right to appeal.
Yes, sir.
All right. So is there a proposed agreement?
There is, Your Honor.
Yes.
It is to deny the motion and continue on deferred, extend the individual for 18 months. And then for DDRF. And then state ISF, the substance abuse track, should he not meet the criteria for DDRF.
All right, so why is he not reporting? You want to raise your right hand for me? Do you
don't.
solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, lower your hand. Why are you not reporting?
I had gotten a hypertension pulmonary lung disorder, and they kept me in the hospital for a month because I was going through a divorce. So then after I got out of the hospital, I got scared.
So when were you in the hospital?
If I'm correct, it was January. No, right after I was done reporting. Had to be June, if I'm correct. January, June, one of those.
So June.
I think it was June. Yes, ma'am.
All right, so you were in the hospital
For a whole month.
for a
yeah.
month, the month of June.
Yes, ma'am. And then they wouldn't let me out. And then when I got out, I was so scared.
When did they release you?
It had to be around July.
All right, so you were
July
released in
20
July.
Like July 29th, if not almost the 30th.
All right, and so nobody's seen you since July.
No, ma'am. And I had gotten scared that I'm not gonna lie, so I didn't report.
All right, this doesn't make sense to me that he's not reporting since July and he has a reason that he was in the hospital.
I understand, Judge.
So does anybody have proof that he was in the hospital?
Paperwork, but it's not with me, of course. It's I have it in my file works at the house.
Well,
I came from the jail, man. That's why.
no, who else lives at your home with you?
Well, I'm to be honest, I don't have a home. I just have my paperwork with a friend of mine,
Oh, who's the paperwork with?
Jessica.
Jessica who?
She Jessica Ambrodos.
Right. You have her number?
No, ma'am, I don't.
Then how do you get in contact with her?
I was staying there for the moment. They just like,
Oh, do you know the number to that household?
no, ma'am, she doesn't have a landline.
All right. So here's the thing. If he is saying that he was in the hospital, which I don't know if it's true or not, I need proof of that.
I have paperwork.
What he's pleading true to is not being in, not reporting January, February, and March of 2024.
All right. So,
He's talking about being in the hospital in June, and he quit reporting because he got scared after that.
Yes, ma'am.
is probation here?
Yes, sir.
Yes. Any objection to the court review and the court summary?
Not from the state, Your Honor.
No, Judge.
All right, could I see the court summary, please?
And we're showing his last report date was December of 2023.
Oh,
So
Okay.
I'm not sure if he's referring to June of 2023.
I think so. Yes.
and probation, why are you requesting DDRF?
For his substance abuse issue, and I'm not sure if he just completed, I think he completed a TAP evaluation in December of 2023, and they were recommending.
Based upon the UAs and stuff, Judge, he does have an issue with the controlled substance.
All right, I don't understand. I'm not going to continue. I don't think you're a good candidate for probation. In this court, I always tell people if they need help,
Sure.
let us know. You've been on probation since 2022. And for that time, you've been missing for well over a year. So the court is going to grant the motion, find you guilty. Would you all like to speak to punishment?
See the.
Probation, did he pay the $60 restitution for laboratory testing?
No, Your Honor. He's
Are-
paid a total of $56.
All right, I am going to order the $60 restitution for laboratory testing. I'll order the therapeutic community. It doesn't increase the time that you're that you're in custody for this sentence. It will just be able to help you with any drug issues you may have, and it appears that you have drug and alcohol issues based upon the court summary. So have you all been able to discuss a time?
No, I've not discussed that with the state has a recommendation.
All right, state, what is your recommendation?
It's the $3,000, like 5 years.
All right. Defense,
Judge, it's a deferred case. On the criminal history, I didn't see anything. I don't see why. Well, first of all, all the reasons have been, there hasn't been any crimes while he's been out. He hasn't committed anything other than testing positive for the drugs that he's taken for the mental issues that he's got. And that's why he was with the dual diagnosis program to begin with. So I'm looking for the minimum of 2, Judge. If you are still going to sentenced to prison. I would like to get him a treatment program to get him into something. But I don't think it fits the needs to sentence him to 5 years.
All right, the court will sentence you to 3 years in the prison, give you credit for any time served. Did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it?
No, ma'am, I don't think I have, I don't.
Well, so this is what has happened. So I've revoked you.
Okay.
And what that means is because there was not an agreement on punishment, then you do have a right to appeal. That right to appeal is limited though. It's limited to whatever the allegations were in the motion that you pled true to.
Yes, ma'am.
You cannot appeal and say, I'm appealing because I was on deferred adjudication and I shouldn't have been on deferred adjudication.
Yes, ma'am.
That ship has sailed. So you do have a right to appeal, but it's a limited right to appeal. Do you understand?
I don't understand that. May you please explain that to me?
All righty. So anyway, did you sign that document entitled Trial Court Certification of Defendant's Rights to Appeal? Is your signature on that?
Yes, ma'am.
All right. Because this was not a plea bargain agreement, you do have a limited right to appeal. Your attorney will explain that to you. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
I understand.
All right, so we're off the record. I'm requesting the therapeutic community for you. It does not increase the time that you're in custody, but it may help with any issues you may have.
Yes, ma'am.
All right, good luck to you, okay?
Thank you, ma'am.
You're welcome.
Appreciate it.
Did
And
you
there,
come up
oh,
with
and
this?
probation, you can be excused. There are no applications on this case. You're welcome.
1:30.
Well, 1:30-ish. Ish, yes.
Mr. Gonzalez was just restored, Judge.
All right. Good afternoon, or, yeah, good afternoon.
Good afternoon.
How are you feeling today? It's not a true question, I promise.
It's a lot better,
Oh,
I
that
gotta
is good.
say.
Yeah.
All right.
All right. All right. Court is calling 2024 CR 4541 and 2024 4494 State versus Rudy Gonzalez. Can I have parties announced for the record for the state? Defense.
Bridget Garza.
And are you Mr. Gonzalez?
Yes, ma'am.
Counsel, in each of the cause numbers, have you received all discovery and reviewed that with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. And each cause number, Mr. Gonzalez, did you review the true bill of indictment with your attorney? And did you understand it?
Yes, Your Honor.
Counsel, in each cause number, do you waive the reading of the indictment?
Yes, Your Honor.
State, in the cause number ending in 4-1, are you proceeding on the indictment as presented?
You are, Your Honor.
And in the cause number ending in 9-4, are you proceeding on the indictment as presented?
No, Your Honor. We're waiving count 1 and the enhancement paragraphs and just proceeding on count 1. Did I say count 1 in the first one?
Yes.
Waiving count 2.
Okay.
I just realized that step right there. And proceeding on count 1. And that's the third degree theft, 30,000 to 150,000 vehicle, Your Honor.
All right, any objection?
No objections, Your Honor.
All right, and the cause number ending in 4-1, you're charged with burglary of habitation, and the cause number ending in 9-4, you're charged with theft, 30,000 to 150,000. Those documents that have those charges in it, it has in there your rights and certain things that you're giving up by entering the plea bargain agreement in each of these cause numbers. Did you review those documents with your attorney? Did you understand them? And did you sign them in all the appropriate places? All right. And the cause number ending in 4-1, the range of punishment is 2 to 20 years. And the cause number ending in 9-4, the range of punishment is 2 to 10 years. If you have a plea, I don't have to follow that plea. If I don't follow your plea and give you more than you bargained for, you can withdraw your plea. And this can be set for trial. Do you understand?
Yes, Your Honor.
Do you understand? In each of these cause numbers, you have a right to a jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes.
Did you understand by entering these plea bargain agreements, you were giving up those rights? And did you intend to give up your rights and enter into a plea in each of these cause numbers? Did you intend to give up your rights and enter into a plea bargain agreement?
Yes,
All right. Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does now, Your Honor. Yes.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
And it's the court's understanding that competency was restored?
Yes, Your Honor.
Mr. Gonzalez, has anyone threatened you to get you to enter a plea in these cases? Anyone coerced you or forced you to enter into these pleas? All right. Anyone promised you anything other than the plea bargain agreement?
Your Honor.
Are you satisfied with the way you've been represented?
I'm satisfied. Yes, ma'am.
All right. Are you a U.S. citizen?
Yes, ma'am.
In each cause number, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. In the cause number ending in 4-1, according to the agreement, punishment is to be assessed at 8 years. There's a $2,000 fine. This will run concurrent with the cause number ending in 9-4. There's going to be restitution to Vakata, VENKATI, Leccareddy, LAKKIREDDY of $500. The state will take in consideration 2024 CR 4493, 4066, and 2023 CR 7253. And the cause number ending in 9-4, according to the plea bargain agreement, punishment is to be assessed at 8 years in the prison. And this is running concurrent with the cause number ending in 4-1. And there are no applications in either of the plea bargain agreements. Did you understand that to be your plea?
Yes, Your Honor.
Defense is at the plea?
It is, Your Honor.
State is at the plea.
It is, Your Honor.
And each cause number, did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yeah.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
No, Your Honor.
All right, then in cause number 2024 CR 4494 to count 1, how do you plead? Guilty, not guilty, or no contest?
Guilty, Your Honor.
And then in cause number 2024 CR 4541, how do you plead? Guilty, not guilty, or no contest?
Guilty, Your Honor.
State any evidence.
Your Honor, in each of the cases, state exhibit number 1 with all this attached.
Any objections?
No objections, Your Honor.
And each cause number, did you review a document? And that document is the stipulations. It has the police reports in it. It has witnesses' statements. Basically, the evidence that the state is submitting to prove you guilty beyond a reasonable doubt. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes, Your Honor.
All right. You do understand that you do have a right to a jury trial. You understand that? All right, so that would mean that witnesses would come in, the state would call witnesses, and those witnesses would testify, and your attorney would get a chance to ask them questions, and nobody could force you to testify. Did you understand? So today, the state is just going to present those witnesses by presenting statements that they've given to the police and police reports. Did you understand?
Yes, Your Honor.
In each of the cause numbers, the court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, in each cause numbers, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Yes, Your Honor. I've been representing Mr. Gonzalez for over a year. And now that he's been able to get some treatment for his mental illness, he's had a clear head. He's pleading guilty because he is guilty. He is remorseful. He takes responsibility. And he wants the court to follow the recommendation of the ADA. He does have a drug problem. He recognizes that. And he understands that when he's in prison, he's gonna have time to reflect on the poor choices that he makes. He's gonna try very hard when he gets out to try to stay off the drugs that caused him to be before the court. And so he's asking the court to follow the recommendation of the ADA.
All right. All right. And the cause number ending in 41, the court will find you guilty, sentence you to 8 years in the prison, give you credit for any time served. There's a $2,000 fine, time and money to run concurrent. This will run concurrent with 2024 CR 4494. Take in consideration 2024 CR 4493, 4066, and 2023 CR 7253. There's to be restitution and no contact with Venkata Lekareddy, and the restitution amount is $500. And I'll order the therapeutic community. The therapeutic community doesn't increase the time that you're in custody, but it may be able to help you with any issues you may have. Do you understand?
Thank you. Yes, ma'am.
You're welcome. I can't force you to be in the program and I can't force them to put you in the program, but they'll see on the judgment that I'm requesting it. You'll still have to ask for it. You're welcome. And the cause number ending in 24. The court will follow your agreement. The court will find you guilty as previously stated, sentence you to 8 years in the prison, give you credit for any time served. This will run concurrent with 2024 CR 4541, and I'll ask for the therapeutic community. Is there anything else with regards to sentencing in each of the cause numbers, state or defense?
No, Your Honor.
All right, in each cause number, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorneys? Did you understand it and did you sign it?
Yes, Your Honor.
All right, because these are plea bargain agreements, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because these are felony convictions, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand? All right, we can go at the record. Here's the thing. Make sure that you ask for the therapeutic community. It's there to help you. Like I said, it's not going to increase the time that you're in custody. If they are planning on releasing you in 2 years, they're not going to say, oh, he hasn't finished therapeutic community, let's not release him. That's not the way it works. And when you're released, if I'm still here and you can't find a place to stay or you can't find, Center for Healthcare Services, just come in and I'll pick up the phone and call somebody, okay?
Yeah.
You can't stay with me, but I'll find a place for you, okay?
Ma'am.
All right, good luck to you, okay? You're welcome. Have a good day.
In the first case, one word changed everything. When the defendant admitted the probation violation, Judge Stephanie Boyd destroyed his last chance at freedom, turning missed check-ins into 3 years in prison. No argument could undo it. No excuse saved him. Probation ended the moment he said true. But the second case tells a very different story. Another defendant, 2 serious felonies, up to 20 years on the line. This time, the ending wasn't sudden, it was negotiated. Judge Stephanie Boyd followed the plea deal, issuing 8 years concurrent, proving that in her courtroom, preparation can limit damage, but mistakes on probation come with no mercy. 2 defendants, 2 paths, 1 judge. And one lesson every defendant learns too late. Judge Stephanie Boyd gives chances, but she never ignores consequences.